All right, this video is about physical and mental examinations and the discovery process. Basically, this is another one of the tools you can use in order to find out information about the case so that you know what the other side says. Physical and mental examinations, particularly physical exams, apply very commonly in personal injury cases. Obviously, you have somebody who's claiming a physical damage in their personal injury, like their injury in their personal injury case. And so you pretty much have to submit to a physical examination about the condition upon which you're claiming and seeking relief. So let me say just a few things about this, and I'll leave you with two bigger questions. The first is physical and mental examinations are done of a party, not a non-party. And the physical or mental condition has to be at issue in a legal action. So if I get in a car wreck case and I broke my leg, I will then probably be submitted to a what they call an independent medical examination, or an IME. You'll often hear it called that. And you go to if you filed the lawsuit against the defendant will hire a IME and an independent medical examiner to then a doctor, in other words, that specializes in the injury to determine whether or not it's legitimate. Did the accident or the car wreck cause the injury? Mental condition, sometimes that's emotional distress damages, or emotional distress is the claim. There are some other areas, mental condition can have a part in whether or not you in an intent, things like that. Typically, that doesn't come up in a personal injury case because it's a negligence crime, not an intent crime. Some of those kinds of things, but you can see that's what those are for. They are oftentimes in personal injury cases. They are to determine the nature and extent of injuries, and you do them for paternity purposes, so that means they would come out in child custody, but that could come out in other kinds of civil cases, particularly involving property, probate, stuff like that. So the first question I ask you in this area is, why do we allow these? Why do we allow physical and mental exams? I mean, what's the benefit to the discovery process? So think about that. If someone does not agree to a mental or physical exam, most are, let me tell you that, most exams of this nature are agreed upon, because basically you have zero claim in a personal injury case if the other side can't come and prove you actually have the injury, or you can't set forth your plaintiff to establish the injuries that you're claiming. In some personal injury cases, slips, trips, and falls, for instance, car wreck cases where there's no overt injury, but there's soft tissue damage, particularly the spine, neck, whiplash injuries. Those have to be examined more specifically. Cases involving whiplash injuries and arthritis are a big one, because I need to examine you to know what is your soft tissue injury, and some soft tissue injuries don't manifest on x-rays, so it gets kind of complicated in that. Most people agree to all that because there's no point in having a case if you can't, obviously if I break my leg or something more serious that you can see, there's maybe not as much need for an exam, but almost always these are agreed upon, and then sometimes they're not. And under Rule 35 of the Rules of Civil Procedure, you can have a compulsory exam. Now, kind of interesting term, but we can compel you to have a physical exam. The answer is, you can't be required to go under a medical exam, but you can be required not to continue your case. So that's the compulsory part. If you don't allow it, and the judge says that there's good cause, and the physical or mental condition is in controversy in the case, okay, so I can't just go in a contract dispute and just be like, the guy is nuts, I want to have a mental exam just to kind of prove a point. I can't do that if the mental condition of one of the parties isn't that issue or in controversy in the case. So pretty much that's the complication factor of it. You can't be compelled. You can be compelled, but you can't be required, by penalty of imprisonment or something, to do a physical or mental exam. It's just that's the terminology. You can be required to give up your case at that point if you don't do it. I leave you with the second question. Should you be required to submit to a physical or a mental examination? Should the court require you to do that? And that's the second question I'll leave you with.